with Monday night quarterbacking, closing the crime. But now, and so I thought it was a good thing that law enforcement was silent. But I think it's important that they come out and start to clear up some of these things. Because what happens is we start chasing shadows. I mean, listen, if that sketch is somehow accurate, it's way beyond my understanding of how somebody could get a sketch based on the images we saw. But maybe that's completely possible. But I'm just always afraid we start chasing shadows. And the more information is out there, then without clarity, we all do, the media, I do, everybody starts trying to make assessments of things, and we very often start going down rabbit holes. So, I mean, look, if it turns out that this was a resemblance down the road, this is all a circumstantial case, barring somebody confessing to this. So all these bits of evidence that you see being recovered, the gloves and all of this stuff, is going to be crucial in the prosecution. So I'm just hopeful that law enforcement is obviously, following proper, which I'm certain they are. The FBI, I have complete confidence in. But, the sketch, is this going to take us all down some, my next door, when I get in the elevator, I'm going to call the FBI because my next door neighbor looks like that. I don't know. I'm a little leery of it personally.
Sure. Let's talk about something else. Let's talk about whether you professionals think this was done by one person or by multiple people acting in concert. Manuel, what do you say to that?
I believe it was done by possibly two, one waiting in the car and the guy going inside, because one of his relaxed how much time he spent to do this. And then you got to remember, this is not a woman that weighs 100 pounds. Judging by Nancy Guthrie, she was at least 150 to 185. She was a, well, voluptuous woman. And to carry that body, dead weight, come on. She didn't walk to that car, Julie. All right, that backpack was full because he had either duct tape, he had rope, and he had something to drag along with him. So I do believe it was possibly somebody with him.
Mm-hmm. Yeah, because you would think, this guy, Nancy Guthrie with her mobility issues, where would she be able to walk? If this clown walked, somebody's got to pick him up somewhere. So to your point, Manuel, that's a great one. When you logically work through it, you would think at least a getaway driver somewhere, because how far could she go? 50 yards was what they said she could potentially do without assistance. That's it. Not very far, and we know this is a remote area, the Catalina foothills, where her home is located. Lieutenant, what do you think about the number of people involved? Your thoughts, please.
Yeah, Julie. So again, we're in a position now, we have breadcrumbs. We have very little information of really what's going on behind the scenes with the interviews that are taking place. We saw them searching the cesspool, the manhole cover of the cesspool. We've seen a lot of things developing beyond just a pure abduction away from the house. So what I would say, look, it's not unusual for somebody to enlist the help of somebody. How many times have we heard that a contractor or an employee was paid a sum of money to commit a murder or abduct somebody? So I do think there's more than one person involved, maybe not in the physical removal of her, because we don't really know anything about the physical removal of her. Where she is, possibly she could be within 1/4 mile of the scene. That's not unusual when a body or a victim is recovered very close to the scene. So I just think we're grasping at straws at this point, and we continue to until somebody gives us a little bit more information, excludes maybe the son-in-law. Some of the family members have not been excluded from this case at all, and they were the eyewitness. If you think of the son-in-law was the only eyewitness to this. He dropped her off, presumably. So again, whether he was involved nefariously or he has more information to provide. But nobody's been excluded. They said they have a few people of interest, but they're being very closed lip on this, and this causes us all to go kind of off the rails trying to figure out what the heck's going on here.
I know, Lieutenant, exactly. Well, great insights from you both, as always, as we head into the weekend and hopefully some answers and Nancy Guthrie's safe return. Manuel Gomez, Mike Gould, thank you both so much. Still ahead this morning, On opening statements, we're talking about a teen girl who was murdered, and there's an older man who's accused of murdering her, allegedly because she rejected him. That's the allegation. Well, this morning, we're being a voice for victims for Demaya Appling. Plus, the au pair comes back to court today. That's right, she's going to be sentenced for her criminal activity. How much time should she get? That's coming up. This morning, we're giving a voice to the victim in the fatal rejection murder trial. Demaya Appling was only 14 years old when she was murdered after she allegedly refused the sexual advances of defendant Waymore Gerhardt. According to the state of Florida, the then 19-year-old Gerhardt lured Appling to his home, made sexual advances towards her, and when she rejected him, he shot her to death. Again, those are the allegations from the state of Florida. Now, during audio recordings of his police interview, Waymore Gerhardt claimed that the sex was consensual and that Appling left and that he just never saw her again.
Why did you take her that night? Because you wanted her and she didn't want you, so you were going to prove a point to her, and you were going to take her and do whatever you wanted with her, and she was going to comply. And when it's not something disgusting when you're having sex with a 14-year-old? That's not something disgusting?
You're accusing me of doing something to her. That's disgusting.
Having sex with her is bad enough.
Would you rather me be honest?
I want to know why she was in your car.
So was this young girl a pawn in some twisted plot for sex? And who was watching out for her? Let's talk about this. Let's bring in the CEO of the National Center for Victims of Crime, attorney Renee Williams, and criminal defense attorney and former prosecutor Joe Tamburino. Good morning to you both. Renee, as you know, this is Teen Dating Violence Awareness Month. And as soon as I saw that we were covering this trial, I thought, oh my gosh, it's hitting right at this month where the National Center for Victims of Crime, does so much to raise awareness, to let people know about dangers. This poor child. Tell me your thoughts about the facts as we know them, please, Renee.
Well, I want to first call out, because we are doing a Voice for Victims, the defense's opening argument. And Joe might disagree with me as a defense attorney. He might say that's all they had and they had to go with it. But one of the very first things this defense attorney did was victim blame Demaya. He described her as a child running the street, using drugs. He did not acknowledge her as a murder victim. And he started out by saying the world failed Demaya, trying to almost dehumanize her, it felt like to me. And again, maybe that's all he had, and maybe he had to go with it. But I just thought in 2026 we were a little bit beyond victim blaming 14-year-olds.
Sure. Fair point, Renee, fair point. And Joe will tell us straight up. Joe, do you think it was in poor taste what defense counsel did?
Well, thanks for having me on. No, only because, when you're a defense attorney, you've got to use whatever you have. I think this case should have been settled. I think that, some type of an agreement should have been arrived at, because the evidence is overwhelming. You've got the DNA evidence. You've got the texts. You've got the nephew testifying against him. You've got the changes of stories. It's overwhelming evidence. So I don't know why the case wasn't resolved before. Now, maybe the state's not offering anything, do life in prison and that's it. So I'm sure the defense attorney, yes, it's untasteful, but he probably has no other defenses.
Yeah. The facts are very bad with this case, period. Waymore Gerhardt is not in a good position on these facts. Let's take a look at a clip. This is from one of the police interviews with the victim's friend.
She was scared. She kept saying, I don't usually get scared, but please just stay on the phone with me till I get to your house. And so I did. When she got to the house, you could tell that she was shook. She didn't say much of nothing, but she was shook.
Maybe because her last words that she ever spoke in her phone by text were that she was with you. And she was scared of you and didn't want to be with you. And maybe that's why you decided to do what you do, because you couldn't have her, but you wanted her. And she wouldn't give you the time of day.
I don't want her at all. I have no girlfriend.
Okay, so a little mashup our editors put together. First, the victim's friend talking about how petrified Demaya Appling was. And then we see the investigator leaning on the defendant in that audio recording that has been played in court, and we have it, and she goes after him pretty good. Renee, tell me your thoughts about how terrified Demaya Appling must have been when she goes to the house thinking she's meeting the nephew, because the nephew is her friend, thinking that that's all it is, and then here it's allegedly Waymore Gerhardt who's coming on to her.
Sure. And I think the important thing to note here is she was a 14-year-old child. And even calling this the fatal rejection case kind of takes some of that away. She was a 14-year-old who was coming to meet a friend. And it's frankly one of the reasons we have Teen Dating Violence Awareness Month, is to bring awareness to the fact that when teenagers are dating for the first time, when they are first having these experiences, they're also not at a maturity level to be dealing with a lot of these emotions. So she probably had a lot bottled up inside of her already. She is showing up for something, and she is still just 14 years old. So her ability to process what was going on isn't as fine-tuned as an adult. And so I'm sure she was terrified, especially with the bait and switch. And I don't think that, this was a fatal rejection. This was her rejecting being raped.
Yes, yes, Renee, I agree with everything that you said. Yes, she's a baby. This is exactly why we're doing this segment right here to spotlight this. She was a baby, 14. He was 19. He was a man, an adult man. Joe, you said earlier you think this should have been settled. Talk to me here, and I always say don't blame the defense attorneys. They've got a tough job. They're protecting the rights of their clients. What do you think the best way to protect him would be? You talked earlier about settling this. What kind of settlement might be appropriate if he did what is alleged?
Well, something where he would have to serve, say, at least 30 years in prison, or maybe even 40 years in prison. Something where he would have at least a little bit of light at the end of the tunnel so that when he turns 60 or 65, he could possibly be released. Something like that. Because, we're going through this whole trial. The evidence is completely overwhelming. I agree with Renee completely that the victim here is a child. 14 years of age. What are you, in ninth grade? Of course she's a child. So to avoid all of that, I would have offered him something where he has the possibility of release. I know that is very distasteful. It's hard to swallow. But rather than go through this whole process and, how sometimes demeaning it is to the victim, I would have offered him something.
Right, Joe. Great points. Try to get some kind of deal with a substantial, as you said, amount of prison time attached and consideration for accepting responsibility. Again, if he did what is alleged, we all know he's cloaked in the presumption of innocence here. Renee, for this victim's family, could we talk a bit about that? With teen dating violence and all of that. We know we have the primary victim, Demaya Appling, but then also you and Joe know this is gut-wrenching for her family to hear this testimony, to hear very graphic details about what was done to her in the brutal way that she was shot and killed by somebody. Renee, what would you say to the family if you had a chance to speak with them?
I think I would tell them first to ignore everything the defense said in their opening argument. I think that was my biggest issue, was they were laying the blame at the feet of her family. This is not your fault. This is one man who was a bad actor and who you never could have predicted. So don't let the Facebook comments and the world piling on tell you that you did something wrong. You did not. I hope that they get a chance to make a victim impact statement. We have found that those are incredibly healing. And so at the end, I hope that they do get a chance to confront this man directly for what he did to their little girl.
Mm-hmm. Right, Renee. Renee, you and Joe made great points today. We thank you both for your insights. And as we're reflecting on Teen Dating Violence Awareness Month here on Opening Statements, we want to, of course, remember the victim, 14-year-old Demaya Appling. She was a child who was loved by her family, especially her grandma. She was the apple of her eye, a beautiful little angel with her whole life ahead of her. And everyone who loves her so much is praying that she gets justice. We'll be right back. Dee Warner. He's accused of murdering his wife, Dee.
After years of searching, her remains are found sealed inside a welded shut storage tank.
The hidden murder of Dee Warner. Live coverage today on Court TV.
She loved her kids. She loved her husband.
I know her innocence.
But she's also charged now with his murder.
I never knew evil like this existed.
Welcome back. Now for what's tipping the scales of justice. Let's talk about it when it comes to Brendan Banfield and his co-defendant Juliana Magalhaes, the au pair. So Mr. Banfield has been convicted of murdering his wife Christine and another man named Joseph Ryan. And he's expected to be sentenced to spend the rest of his life behind bars, which is the mandatory penalty for aggravated murder in the Commonwealth of Virginia. But later this morning, we'll find out what will happen with the au pair. So she pleaded guilty to the crime of manslaughter in the death of Joseph Ryan. Remember, she testified and admitted that she shot him. Court TV's Kelly Craft has more.
Juliana Magalhaes came from Brazil to live and work for Brendan and Christine Banfield as their au pair. But less than a year later, Magalhaes became something more to Brendan.
At some point, while you were working for the Banfield family, did your relationship with the defendant change?
Yes.
How did it change?
It became sexual, physical relationship.
The two became lovers, but kept their relationship a secret from Christine. As their affair grew more serious, she said Brendan came up with a plan to get rid of his wife.
Did he give you more information or more detail about what he intended to have happen?
Yeah, he said he wasn't going to hire anybody because that is something that throughout the investigation can be discovered easily, and that he had heard of a website called FetLife.
Magalhaes said she and Banfield opened an account on FetLife, a fetish dating website, using this picture of Christine. They started looking for users willing to come to the house to act out a rape fantasy. She said Banfield eventually chose Joseph Ryan for the role.
Did he say why he picked Joe?
He would be the person to play the role they needed the person to play, which means being aggressive and hold her down and come over to the house and bring stuff.
The items Ryan was asked to bring included restraints and a knife. The plan was for Banfield to wait at this McDonald's for Magalhaes to call and alert him to Ryan's arrival. Banfield would then return home, kill Ryan, and then frame him for Christine's murder.
Do you swear or affirm to testify truthfully in this case under penalty of law?
Charged with aggravated murder, Brendan Banfield testified at his own trial and told jurors that it was Joseph Ryan who killed Christine.
I saw him do a downward stabbing stroke, and that's when I fired at him.
Not true, according to Magalhaes, who testified it was Banfield who killed his wife.
He got on top of her, and that's when I first saw him stab her with a knife.
Where in her body was he stabbing her?
Her neck.
I understand we have a verdict?
The jury deliberated for nearly 9 hours over 2 days before reaching the verdict.
We, the jury, find the defendant guilty of aggravated murder of Joseph Ryan and Christine Banfield as part of the same act.
Magalhaes pleaded guilty to involuntary manslaughter in a deal with prosecutors. This was in exchange for her testimony against Brendan Banfield. Prosecutors agreed to recommend time served, but it will be up to the judge to decide how much time she will serve for her role in the killings.
That was Kelly Craft reporting for us. So 11:30 a.m. Eastern is the time that the au pair will go back before the Honorable Penny Azcarate to learn her fate. So what should the judge do with her? Let's bring in our legal analyst guest and pose that question, criminal defense attorney and former prosecutor Joe Tamburino. Joe, what do you think? What should the judge do with the au pair?
I would give her 10 years. I don't think the judge is going to do that, but that's what I would do. And, you know, the timeline here is very interesting because, you know, she's arrested, Juliana's arrested, I believe, in September of 23. And then a year goes by and Brendan's arrested. And then a month later, in October of 24, Magalhaes and the prosecutor strike this deal. And then basically 2 months after that, in December of 24, you get an indictment against Brendan. But what I'm interested in is what happened in that year. from the fall of 23 to the fall of 24 when Margulies is in custody. What's happening on her case? Why did the prosecutor make this kind of a deal? I could see the manslaughter deal, sure, but we're going to recommend that you walk right after sentencing. I mean, that is so unique.
You're right, Joe. It is. By the way, Joe for judge, saying you give her 10 years. I'm with you. I'm with you. Max her out. She should be maxed out. 10 years, as Joe noted, the maximum penalty for manslaughter in the Commonwealth of Virginia. So that's as much time that the judge has. You know, when you think back about that year, Joe, we know the defense position was that the government leaned on her, that they leaned on her and, you know, put their thumb on the scales of justice, so to speak, to get her to make up this story. That was the defense theory, the defense position. I think they really needed her because this guy did such a good job covering his tracks. I don't think that she was leaned on to make up a story. I think she was leaned on to testify and maybe doesn't understand how it works here in America. But I agree with you. There should be a hefty penalty. It should not be a time-served recommendation. Joe, do you think they did that, you know, because they know at the end of the day, the judge can do what she wants? You know, we can promise you the recommendation, but whoopsies, if the judge gives you 10, sorry, we held up our end of the bargain.
Yes, and that's what I think is likely going on because, you know, the prosecutors did a really good job in this case, so I don't see them as inept or anything like that. No, I'm not saying that at all. But I think you could very well be right, which is they said, look, here's the 10 years, and sure, we're going to recommend that you be released from prison, knowing all well that a judge is not going to do that. But, you know, I mean, today, I wouldn't be surprised if the judge gives her something like 5 years. I wouldn't do that, but I wouldn't be surprised.
Right, Joe. Judge Penny Ascarate, who we've seen before, highly respected judge in Fairfax County, Virginia. She presided over the Johnny Depp, Amber Heard landmark case, and she has a reputation of being a very tough, no-nonsense judge who knows the law, knows the rules of evidence. And we've seen her in action. She is excellent. She has served in our Marine Corps. I would not want to take my chances in front of her, you know, with the au pair, like to not have, you know, and I mean, but look, what can the au pair do? I mean, she's not in a position to bargain. She's going to have to just, you know, take her punishment. I think the judge is going to give her a hefty one. Joe, what do you think the judge will do? Do you think she'll give her close to 10 or 10?
I think she's going to give her 5 years. And I think what the defense will argue is two things. Number one, that Margulies was absolutely critical to get a conviction on Brandon. Without her, no conviction. That's what they're going to argue. They desperately needed her, and she did her job. The second thing they're going to argue is, look, Judge, if you give her the max, you're sending a signal out there for people not to cooperate. Because, you know, the prosecutor needs people to cooperate, whether it's in organized crime or street crime or domestics, whatever it is, the prosecutor needs to be able to get certain individuals to cooperate. And Judge, if you just simply throw the book at her, what you're doing is you're sending a signal out there saying, don't cooperate, because if you do, you're going to get the max anyway. I think that's what they're going to argue. But in the end, I think the judge is going to do 5 years. I would do 10.
Joe, all really sharp points you made, and you really got me thinking about how, you know, I don't know if the prosecution could have proven this without Juliana Margulies. I mean, really, taking a step back, like I was thinking as you were talking, I'm going, you know, she really did make the case for them. So to your points, she deserves some credit for that. Again, 11:30 a.m. Eastern Time is the time that the sentencing will happen, and of course we'll be covering it here on Court TV. Joe Tamburino, always wonderful to have you as a guest on the show. Thank you so much. Friends at home, thank you for being with us here on Opening Statements. If you like the show, you can watch it again. Go to courttv.com, just click on that shows tab. We put the episodes up for you every weekday morning. In just 4 minutes, it's time for Court TV Live. We got a lot on the docket, including the Hidden murder of Dee Warner trial. Good Friday morning to you, and welcome to Court TV Live. I'm your host, Julie Grant, and it's a busy Friday this morning already. Let me show you the trials we are tracking for you today. In New Jersey, we're on verdict watch in the Mansion murders trial for defendant Paul Caneiro. In North Carolina, we've got the judge expected to announce his ruling on whether Austin Thompson will receive life in prison with or without the possibility of parole. Court is set to start up in just about a half an hour from now. We will go there live when it begins. And in Michigan, we've got the state's case resuming in the trial of defendant Dee Warner. This guy's accused of murdering his wife, Dee Warner, and hiding her body in a sealed tank on his property. Before we go live into that Michigan courtroom, let's get you the background of this case. Court TV's Ashley Wilcott reports.
We're at the final resting place where we found Dee's body entombed in one of these anhydrous tanks.
It was a gruesome discovery for the family of Dee Warner, who spent years searching for her. The mother of 5 vanished in April of 2021. What followed were extensive searches of the sprawling property she lived on with her husband, Dale. Acres combed through with no sign of Dee.
We've had 3.5 years of searching, right? And there's been every single thing, even though we've had anticipation at a number of times, they've all been a no-go.
Greg Hardy is Dee's brother. He suspected Dale Warner of having something to do with her disappearance. Dale told police his wife left on her own after they had an argument, but Dee didn't take her car and she didn't tell anyone in her family where she was going.
We worked as hard as we could to investigate and make the investigation work, and finding her body and laying her to rest validates the fact that we weren't just trying to incriminate someone. We knew this wasn't what Dee would have done.
The sealed fertilizer tank in which Dee's remains were found was in a barn on property owned by Dale, located about 4 miles from their home.
This was done to her viciously, so it's a validation of what we worked for so long is true. It's up to the court in the trial to find him whatever justice he deserves.
Dale Warner is charged with murder and tampering with evidence in his wife's death.
State of Michigan versus Dale Warner. Appearances, please. Can we state your name, sir?
Dale Warner.
Warner rejected a last-minute plea deal before the start of his trial. He maintains his innocence and claims that he had nothing to do with his wife's murder.
Ashley Wilcott reporting there for us. We want to give you a live look at the courtroom in Michigan. Things are not quite yet underway in this case. We see the attorneys milling about the courtroom, getting prepared. The judge not yet on the bench. The clerk is there, and the defendant is not there yet. He is incarcerated. The jury won't know that. But we're watching and waiting for him to be brought in from the jail and for testimony to get underway. If you missed day number 1, it was a big day with Dee Warner's daughter, Amber Million, giving testimony. Now, she belongs just to Dee. Let's go in and watch some of her testimony now.
How did you know Dee Warner?
It was my mom.
I'm going to ask you to speak up real loud.
She was my mom.
Okay. And do you have siblings?
Yes.
Who are they?
TJ Bach, Zach Bach, Raquel Bach, and Angelina Warner.
Okay. And your maiden name is Bach?
Yes.
Okay. And the 4 Bachs, who is your dad?
Timothy Bach.
Okay. And so your mom and Tim were married?
Yes.
Okay. And how did you know Dale at that point in time when your mom and Tim were married?
Yes.
Okay. And at what point did your mom and Dale get into a relationship?
They worked together at, I can't remember the name of the company, but it was a chemical fertilizing company, I believe.
Okay. Did you do your very best to speak as loud as you can?
Sorry.
So you said they worked together?
Yes.
How old were you at that time?
Probably between 13 and 14.
Okay. And did it come a point when your mom and Tim got divorced?
Yes.
And that was about that same time, about when you were 13 and 14?
Yes.
Okay. And then what happened with Dee and Dale? They got married, is that correct?
Years later.
When was, after Friday night, when was the next time you saw your mom?
After Friday night?
Right.
Saturday morning.
And do you remember approximately what time?
It was in the morning, maybe between 9 and 10.
Okay. And do you know, where did you see her?
My house. She came to my house.
And do you know why?
To pick up my sister, Angelina, for a soccer game.
Okay. And again, do you have an approximate time when the soccer game was?
Around 10,
Okay.
10:30.
All right, and so do they go to the soccer game?
Yes.
All right, and what are you doing, just generally speaking, on that Saturday?
I'm working from home.
Okay, and what kind of work do you do?
I'm a nurse.
Okay, and you can do your work from home?
Yes. I was a triage nurse at the time.
Okay, and how do you do your work from home?
I speak to patients and help them troubleshoot issues from home.
Okay, people who've had surgery?
Yes.
Okay. All right, so do you see your mom again on Saturday?
Yes.
About how much later?
About an hour and a half to 2 hours later after the game.
Okay, and again, approximate time frame?
Between 11 and 12.
And is there anything about when she came back that you remember?
She was hysterically crying when she came in to the house.
Okay. Where were you when she came in?
I was at my desk in my room.
Okay. And so she just, Dee just came in the house?
She came in the house and directly into my room.
Okay. And what happens when she gets in your room?
She sets her phone on my desk with a text message opened.
Okay. And if I showed you that text, would you remember it?
Yes.
All right. Showing the witness people's proposed 87.
Yeah.
That's the one she showed you?
Yes.
Did you read it at the time?
Yes.
What was the gist of the text?
Somebody was mad at her for getting in their business and
Okay. What was your mom's reaction to that text?
she went, after she set the phone on my desk, she went directly into my bathroom connected to my bedroom, and she threw up and was crying and just saying she was done.
And did you know what she meant by when she said she's done?
She said, "We're selling everything, I'm done."
This is 8033, a future plan or intent. Go ahead. What was she saying about what she wanted to do?
She said, "We're selling everything, I'm done."
Okay, and what did you take that to mean?
She was done with her marriage.
Okay, did the text that she showed you involve Dale?
Yes.
How did it involve Dale?
At the end of the text message, the person said, something along the lines of, even your husband says you're a mess and takes Xanax.
Our hearts break for Amber Million. Again, she's Dee Warner's daughter, not Dale Warner's daughter, just Dee's daughter. And she gave testimony on the first day of this trial that's about getting justice for her mom. So we continue to wait for the testimony to begin. We have a live picture of the courtroom. We'll continue watching things in Michigan for you. In the meantime, we have a very famous defendant making his arraignment appearance in court in Massachusetts. NFL star Stefon Diggs just appeared in court. We're going to show you that hearing when we come back.
In 2021, Dee Warner vanished without a trace.
Dale Warner. He's accused of murdering his wife, Dee.
Rumors of a troubled marriage spread throughout this small community.
She had contemplated divorce several times.
Now, after years of searching for Dee Warner, her remains are found on the couple's property.
Sealed inside a welded shut storage tank.
We're still going to fight to the end to see that she gets her justice.
The hidden murder of Dee Warner. Live coverage today on Court TV.
Welcome back to Court TV Live. I'm Julie Grant. We're going to take you back into the courtroom in just a moment in Michigan. But first, we want to update you on another case happening in Massachusetts. So fresh off of a Super Bowl loss, New England Patriots wide receiver Stefon Diggs is in court for his arraignment. Diggs is being accused of strangulation and assault relating to an alleged incident with his private chef back in December. The arraignment was initially slated during the playoffs, but then was pushed back until after the season ended. Let's take you into the courtroom now.
This matter is a matter of the Commonwealth versus Stefon Diggs.
Good morning, ADA Drew Virtue to the Commonwealth.
Good morning, Your Honor. Andrew Kettle for Mr. Diggs. Waiving the reading, sir? Yes. And not guilty plea will enter.
All right. Commonwealth, any requests?
Commonwealth's pressing a stay away, no contact from the victim, including third-party contact.
Any counsel?
No.
All right. Those orders one.
And next date, sir, April 1st? We can have April 1st for pretrial motions. Pretrial motions. All right. So, sir, on this matter will be continued until April 1st, 2026 at 9 a.m. As for a pretrial hearing, being released today on their own personal recognizance with the conditions will be released. They to stay away and have no contact with the named victim, and that includes third-party contact. Please be advised if you violate the terms of your release, or if you commit a new criminal offense during the pendency of this case, your bail or personal recognizance could be revoked, and you can be held without bail for up to 90 days. So that's April 1st at 9, sir. Please see probation today before you leave. Thank you.
Thank you.
Thank you, Your Honor. Thank you. Following a CMBI appeal, this is the matter of the...
Okay, and that is just how quickly an arraignment happens on charges like this, facts like this. This defendant is 32 years old, again, a star wide receiver for the New England Patriots, and he is being accused of assaulting his personal chef. Stefon Diggs, a famous guy, 32 years old, reached fame at a very young age because of his skills on the football field. He's also been in headlines for dating Cardi B. And as I reported moments ago, he was supposed to be arraigned several weeks back, but the arraignment was continued for him to finish out the season, went all the way to the Super Bowl, and now his next court date's going to be on April the 1st. He's out on bond, and we'll see what happens on that date. We'll see if he pushes ahead to fight this. Perhaps he'll take it all the way to trial. Don't know. But again, the allegations are that he strangled or suffocated his personal chef. So he's got a felony strangulation or suffocation charge, as well as a misdemeanor assault and battery charge. Again, those are the allegations. Stefon Diggs is cloaked in the presumption of innocence. The alleged incident happening on December the 2nd. He has denied the allegations and entered his plea of not guilty. So the case moves forward from here. We've put it on our docket for you at Court TV, and we will continue tracking it. Now, let's take you back to Michigan. I told you earlier, it's a busy Friday morning. We've got the trial of Dee Warner going on today. This guy's accused of murdering his wife, who was once believed to have gone missing. Well, she ended up being found buried on his property. And we heard from her daughter, Amber Million, on day number 1 of this trial. You heard her direct testimony moments ago. Now let's hear what happened on cross.
You had testified that you were in high school when Mr. Warner and Miss Warner got together. Is that correct?
Yes.
And you observed them fighting a lot throughout the time that they were together?
Yes.
But you never saw physical violence between Mr. Warner and Miss Warner?
No.
You never saw Mr. Warner on the verge of hitting Miss Warner during any of these arguments?
No.
You never saw him get close to her during these arguments?
No.
And I believe on direct you indicated that your mom brought up divorce many times. Is that accurate?
Yes.
It wasn't surprising to you when she would say things like this?
No.
According to you, I think you said she brought it up millions of times. Is that accurate?
I did not say millions.
Do you remember having an interview with the police in November of 2022?
Yes.
Do you remember saying that it was 1 million times according to you?
Possibly.
And she brought that up on April 24th, 2021.
Yes.
Mr. Warner's response to Miss Warner saying she wanted a divorce was, okay, whatever, Dee.
I don't remember.
Would looking at the police report help you refresh your recollection?
Sure.
Ms. Taylor, can you do GWR02, page 57? And just read that and let me know when you are done.
Okay.
Did that help refresh your recollection?
Yes.
That was Mr. Warner's response to, I want a divorce. Okay, whatever, Dee.
Yep, that's what I said.
Objection. Can we get some clarification on the time frame of when this okay, whatever, Dee response is?
You had a conversation with your mother about wanting a divorce. She wanted a divorce from Mr. Warner on April 24th, 2021. Is that correct?
Yes.
And she actually indicated that to Mr. Warner before she had come over to your house.
Okay.
Do you agree with that?
I might have said it at the time. I can't remember specifically the conversation now.
Would looking at the police report again help?
It looks like I said that, yes.
Okay, and based off that, on that same day, April 24, 2021, Mr. Warner's response was, okay, whatever, Dee.
Yes.
She also in the past had threatened to be done with businesses and sell it all, correct?
I don't recall.
Would listening to your interview to the police help you refresh your recollection on that?
Yeah.
Okay. Did that help refresh your recollection?
Yes.
So your mother, Miss Warner, she threatened in the past to be done with all of the businesses and wanted to sell them all. Is that correct?
Yes.
And she'd said that many times before?
Yes.
You would describe your mom as dramatic?
I guess.
And it's not abnormal for her to argue?
No.
Going to April 23rd, 2021, you picked your sister up, Angelina, from school.
Yes.
And she spent the night at your house, which was actually something common for her to do. Is that right?
Yes.
Your mom came to drop off clothes for her on April 23rd?
Yes.
And at that point, you had spoke to your mom, had a conversation?
Yes.
And your mom didn't complain about anything unusual. It was all normal things she would discuss. Is that accurate?
She was complaining about business things, but I don't remember specifically.
Is that normally something that she would discuss with you and have complaints about?
Yes.
And you testified that the next day, April 24th, she picked up Angelina around 10 a.m. Is that accurate?
Around.
The day that she went to the soccer game, she was wearing leggings, black slip-on shoes, and a black zip-up.
That's what I remember.
You mentioned that she was upset about Mr. Warner mentioning her use of Xanax to other people.
Yes.
And just to be clear, your mom had also said negative things about Mr. Warner as well throughout the course of their relationship.
To me?
Yes.
Yes. Yes.
And when your mom was at your house that Saturday, April 24th, she was starting to get a migraine?
I don't recall.
Would looking at the video or listening to the video of your interview with the police help refresh your recollection?
Possibly.
Thank you.
Okay.
Did that help refresh your recollection?
Yes.
She started getting a migraine that day on April 24th?
Yes.
And she took medicine for it?
That's what I said, yes.
Just lastly, on April 25th, you were not alarmed at first when nobody could find your mom?
Not right away.
You thought she left because she was mad at Mr. Warner?
Correct.
And you were not worried because that's something she had done many times before?
Yes.
Okay, this young lady holding up very well on the cross-examination. This has to be brutal for her. Remember, it's her mom who's the victim here. And the question is, was it her mother's husband who murdered her? We'll find out as this trial continues rolling on in Michigan. They haven't yet started the day there. We're monitoring the courtroom this morning. There is some action going on in another courtroom, the one in New Jersey where Paul Caneiro is being tried. We understand that there is a note from the jury. We continue on our verdict watch next live. Welcome back to Court TV Live. I'm Julie Grant. Let's get you to New Jersey. The jury has a question in the Mansions murder trial.
I want the two of you to look at it also to confirm what they're doing. I want you to be comfortable with exactly what's going to go on the screen. But Mr. Decker, I just want that area of time that they're asking for, the back of the vehicle. So it's probably not more than 5-7 seconds or whatever it is. It's not the entire video that they're asking for. They're asking for the back of the vehicle. All right? Sir. Can we mark this as a CJ2, please?
So did you officer that? Left and back. So was it supposed to be?
Okay, we're on a verdict watch. Don't know what that question is that the jury has, but here's what we have to do. We're going to let them figure things out in New Jersey because something else is happening in North Carolina. The judge has just taken the bench in the teen killing spree sentencing. This is for defendant Austin Thompson. It's been going on all week. Testimony regarding whether he should get life in prison with or without parole. He went on a shooting spree, murdering 5 people, including his own brother. Let's go in and hear his fate.
All right, good morning again. Ladies and gentlemen, thank all of you for your participation and professionalism throughout these proceedings. I particularly thank counsel for the informative and professional way in which each of the counsel have conducted themselves under these difficult circumstances. I also commend those of you who are in the gallery for your professionalism throughout these proceedings so that we can conduct these proceedings in a way that befits the gravity of the situation but also achieves the ends of justice. Before I get into the details of sentencing in this matter, I too also, like the state in its closing argument and the defense in its closing argument, like to simply just redirect the attention for a moment on the victims of this case. This is certainly an important day for them as well. These proceedings are important. They reflect the constitutional rights that the victims have the right to be present and to be heard at proceedings like this. And I want to just say briefly a bit that I learned about each one of the victims. What I learned about Lynn after 3 months in the hospital, life support, her mouth wired shut, buckshot fragment found in her body, 5 buckshot fragments found in her body, 1 remaining, parts of her internal organs removed. She, our first witness, sat on the witness stand and said that God has given her the grace to forgive the young man that shot her. Reflects a beautiful soul. Nicole, what struck me was she was loved so fiercely by her husband that the defendant's actions have broken him. He doesn't enjoy things like he used to. He feels socially awkward. He doesn't like to go anywhere because he feels guilty about having fun without his wife. Gabe, former U.S. Marine, Raleigh police officer, a really great husband and father. We heard a powerful statement from Jasmine about the impact this has had on her. And Layla, Gabe's daughter, knows her father only through photos, videos, and a cutout pillow with his image on it. Casey Clark, Raleigh Police Department for 10 years, a member of the Selective Enforcement Unit, the SWAT team. His entire life goal was to be on that unit. It was his dream. He was only able to live that dream for 3 years before, while protecting the citizens of our community, he was shot in what felt like a freight train going through his knee. He's not able to continue in the law enforcement profession and still has a bullet in his leg. James Thompson, son of Elise and Alan Thompson, honor roll student, 4.12 GPA, saving money from his odd jobs for a car in college, all-around athlete, excelled in team sports, a good son, couldn't ask for anything better. Sue, a runner, marathoner, ultra marathoner, mother of Max, Oliver, and Everett. Every day when her husband Tom wakes up, he realizes his wife is not there, lying beside him, and that makes that day hard. And he knows that that will be his experience every day for the rest of his life. Mary Beth Marshall. I really love Jenny's description of Mary Beth as the home entertainment system of their family. Singing loudly, off-key, silly jokes. And I really like this description. She had laughter that can only be described as what sunshine sounds like. We turn our attention now to the sentencing in this case. And I'll start with a brief statement of the law that governs the task of the court with respect to the sentencing hearing. There was a little disagreement about what the law actually is in the closing arguments. In 2025, the North Carolina Supreme Court in State v. Sims said, quote, "The inquiry is not whether a defendant is permanently incorrigible or irreparably corrupt, nor is it potential for redemption," end of quote. Both the United States and Supreme Courts hold that life without parole should be reserved for the rare juvenile offender whose crime reflects irreparable corruption. So the purpose of this hearing is to answer that question. Is Austin Thompson the rare juvenile defendant whose crime reflects irreparable corruption?
What are your thoughts on whether Austin Thompson should have the possibility of parole? Let's ask our legal analyst guest to that question. He is an attorney for the city of Hampton, Virginia, prosecutor Anton Bell. Good morning, Anton. What are your thoughts on that question, please?
So, good morning, Julie. I have prosecuted juveniles, and one in particular I'm thinking about is a 16-year-old who killed 2 people in a very egregious manner. And the judge wanting to give him life, but was afraid at the time that the Supreme Court would rule a certain way in Virginia concerning life sentences. He gave him 160 years to serve, which is essentially a life term. And I had no problem with that. This particular individual was of such a nature, the way the crime was committed, such as with the Thompson case, the way the crimes were committed just showed somewhat of a sociopathic mindset. That person cannot be rehabilitated. And if you release that person from custody, you're going to have more blood on your hand.
Great points, Anton. Thank you much. We'll hit a break. When we come back, we'll go back into the courtroom and hear more of His Honor's opinion. This is the sentencing of the teen killer named Austin Thompson. A deadly school shooting.
I just started hearing gunshots. Now, the father of the alleged shooter is on trial.
Mr. Gray knowingly allowing his son to possess a weapon
that gave my son a gun murder trial today on Court TV.
She loved her kids, she loved her husband.
I know her innocence.
But she's also charged now with his murder. I never knew evil like this existed.
has given me the grace to forgive the young man who shot me. I'm not forgiving to free him. I'm forgiving to free me.
To know that my son, who I carried for 9 months, caused all of this heartache and tragedy is still a complete shock.
This is Austin 2.0 in a way. He is not the same human being as he was when he was a 15-year-old with intact frontal lobes.
Back to the courtroom now. We're in the sentencing hearing, And at the point of the hearing where the judge has heard all the evidence, all of the testimony, and he's going to make his decision about what to do with Austin Thompson. Let's go back in live.
When a juvenile, as Mr. Thompson was at the time of these offenses, has been convicted of first-degree murder on the theory of premeditation and deliberation, the sentencing court must conduct a sentencing hearing to determine whether a sentence of life without the possibility of parole is warranted. At this hearing, the defendant or defendant's counsel may submit mitigating circumstances to the court, including but not limited to
Yeah, of course. Do you need to put anything on the record?
No, I think we're in agreement with the
Okay, so we're all in agreement. We have them both teed up. See?
One at a time, but yes. Yep.
Yeah, sorry. Knock on the door.
Come on out, folks.
So at 9:42, I received the third note. Sorry, just want to make sure we have it right of exactly what you're asking for. This is and we marked it as CJ3. It says showing vehicle going and returning from video 263 D1. Please freeze so we can see the running lights. And then the second one is returning vehicle from 263 M1.1. So you can see that same, and you gave me a copy of 263 M.1. So we see that, we're going to show that, and we're also going to show 263 D.1, and we're going to stop it so that you'll be able to see it. So we'll do that now. If we could turn off all of the lights, please. Okay, you can unfreeze it.
Can you freeze it there?
Can go back a little bit. I just heard the jurors say that they wanted it paused again, so go back a little bit more. Back a little bit more. Tell us when to stop.
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 Right there. There, and then one more after that.
Like a second after.
A little bit further. Further there. There.
Okay, that was the area going out. Everyone good with going out?
Yeah.
Now we're going to do the return. Pause. Do we have everything you need?
I do.
Yes.
Okay. All right, ladies and gentlemen, you can go back and you can continue your deliberations. We can turn the lights back on, please. Yeah. And we can give them back these exhibits also. I'm just going to keep the note. Could you ask them to give us the other two notes back so that I have them secured, please? Thank you. Okay, our alternates, you can go back to your location, please. Thank you so much. Good counsel, anything we need to put on the record?
No, Judge. I got you.
Okay, all right, thank you all.
Good Friday morning to you, and thank you for being with us here on Court TV Live. I'm your host, Julie Grant. Let's get you back into the courtroom right now.
Each of the 5 homicides was perpetrated in a manner that reflected utter and callous disregard for human life. Defendant shot James in the head from a close distance, and then, despite his mortal wound, dragged James into the bathroom and mutilated him with over 57 stab wounds to the neck. Defendant then selected 2 weapons, a 9mm semi-automatic pistol and a shotgun capable of holding 5 shells at a time. For the shotgun, defendant chose double buckshot shells, each shell holding 8 or 9 pellets the size of 9mm slugs, ammunition designed to cause devastating damage. Defendant then dressed in camouflage, packed a survival bag, stockpiled over 100 rounds of shotgun shells and extra 9mm magazines, and exited his house. He immediately spotted Nicole and Lynn on the sidewalk walking their dogs. He ran towards them, ambushed them with multiple close-range shotgun blasts to their torso, head, and necks, and then he shot Nicole in the head with a 9mm pistol. He shot Sammy, her dog, with the pistol as well. The defendant then headed to the Greenway. Jogging through the neighborhood, he encountered Gabe, the Raleigh police officer, leaving his home to start his evening shift. He shot Gabe in the head and neck at close range with 3 shotgun blasts. Continuing on to the Greenway, defendant encountered Mary Beth, and again, at close range, shot her with 2 shotgun blasts at close range to the head and neck. Finally, a bit further down the Greenway, defendant came upon Sue and shot her at close. Than the conduct of the defendant in his indiscriminate killing of 5 innocent homicide victims on October 13, 2022. Malice is one of the elements of first-degree murder. It is defined under our law as meaning not only hatred, ill will, or spite, as that is ordinarily understood. To be sure, that is malice. But it also means the condition of mind that prompts a person to intentionally inflict damage without just cause, excuse, or justification. And quite frankly, it's hard to conceive of a greater display of malice than what I've just described. Second, defendant's crime were the product of months of fantasizing, planning, and preparation, and not the product of transient immaturity, such as impulsivity, peer pressure, or poor decision-making abilities, and cannot be viewed as being significantly influenced by neurodevelopment differences of development of a 15-year-old as opposed to the brain of a fully mature adult. In this regard, the court finds that the internet search history is to be information on Rudolph's hiding in the mountains. Did he make his bombs, including searches for images of Rudolph's pipe bombs? From January 2020 to November 2021, defendant made many internet searches researching how to build bombs and explosives. Notes hidden in defendant's bedroom included rudimentary schematic drawings of homemade bombs of various designs, such as ones detonated by a tripwire or by a phone or upon opening a package, or a pipe bomb. He wrote detailed handwritten recipes for the manufacturers of explosives like ANFO and dynamite. For the 2 years leading up to just a few days before defendant's October 13, 2022 murders, defendant consistently conducted internet searches on mass shootings and school shootings, included searches for the fastest school shooting, the deadliest school shooting, the deadliest middle school shooting, all school shootings done with a pistol, and a list of school shootings that killed 10 people or more. In the 2 months prior, immediately prior to the murders, defendant's searches became more prescient. During this 60-day time frame, defendants queried whether someone can talk if their voice box is cut out. Do most people scream after being stabbed in the neck? Can you hear someone shoot a .22 inside their home? How fast does a .22 have to go to penetrate a skull? On August 30, 2022, defendants searched humans destroying the planet. And on September 26, 2022, defendant also searched for mass shooters who hate humans. He queried, how much does 100 shotgun shells weigh? On October 1, 2022, he asked, how deadly is double-aught buckshot? And on the same day, do police go into the woods by themselves to pursue someone? This written evidence, namely the evidence of research and planning conducted by the defendant in the months and most notably immediately prior 60 days, is closely mirrored to the actions carried out by the defendant on October 13, 2022. After 7 months of researching Eric Rudolph, who was the mass murderer who committed acts of terror and evaded capture for many months by hiding in the woods, defendant, on October 13, packed a survival bag and headed into the deep woods after committing mass murder. After researching the lethality of double-aught buckshot, on October 13, defendant chose that as his instrument of murder. After researching the weight of 100 shells, shotgun shells, on October 13, defendant packed approximately 100 shotgun shells to carry with him for his escape. After researching whether one could hear a .22 fired inside his house, on October 13, defendant shot his brother with a .22 inside their house. After researching whether someone could talk if their voice box is cut and whether a person screams when stabbed in the neck, on October 13, defendant stabbed his brother in the neck over 50 times, and a reasonable inference from the evidence is that he attempted to cut James's voice box out. After researching mass shooters who hate humans and humans destroying the planet, on October 13, defendant wrote a note. He left after murdering James, saying defendant hated humans because they were destroying the planet. These facts reflect a defendant who for many months, and certainly several months prior to committing murder, fantasized, researched, and planned his criminal acts and his escape. On the day he committed the murders, he confirmed his sanity, his culpability, and his lack of regret in a written note. This lengthy period of premeditation and deliberation, when coupled with the pure malice displayed towards his random and innocent victims, are compelling findings that support the conclusion, or a conclusion, that Austin Thompson is one of those rare juvenile offenders whose crime reflect irreparable corruption. Third, the court finds that the defendant was an intelligent person with the ability to fully appreciate the consequences and risks of his actions, and did indeed appreciate those consequences. By all accounts, from defendant's parents, his teachers, defendant was highly intelligent and inquisitive person. He suffered no apparent mental health defects, no developmental disabilities, no health issues. A frequent research topic of defendant's internet queries related to consequences for various categories of criminal conduct: homicide, rape, bank robberies, assaults. Indeed, in the months prior to the murders, defendant specifically researched Can juveniles get life without parole? And how many years is a life sentence without parole? Defendant, after killing James, wrote a note. He says he shot James and stabbed him, and that James stopped breathing 10 or 15 minutes later. He wrote he killed James because he would get in the way. He said he was not bullied, that he was not mental, was sane when I did this, he was not suicidal, that he did not want to die, but that it was going to happen. He wrote he had no regrets. He tore a corner off the note and wrote, "James is dead, don't look inside," and placed it near the bathroom door with the spent .22 cartridge casing from the bullet James was shot with. This evidence, a manifesto of sorts, supports a finding that defendant clearly understood the risks associated with his planned course of conduct, including life imprisonment or his own death, and further felt it important to document the intentionality of his actions, his lack of regret, his motive, and to negate defenses such as insanity, suicidal ideations, bullying, and other factors which might be used to excuse his conduct. Fourth, the court finds that the evidence and the record before the court does not support the conclusion that defendant was experiencing a neuropsychiatric side effect of acting.
Thanks so much for watching along here with us on Court TV Live. We'll hit a 4-minute break, and we'll see you on the other side.
In 2021, Dee Warner vanished without a trace.
Dale Warner. He's accused of murdering his wife, Dee.
Rumors of a troubled marriage spread throughout this small community.
She had contemplated divorce several times.
Now, after years of searching for Dee Warner,
her remains are found on the couple's property, sealed inside a welded shut storage tank.
We're still going to fight to the end to see that she gets her justice.
The hidden murder of Dee Warner. Live coverage today on Court TV.
It's wonderful having you with us on this Friday morning. I'm Julie Grant, and this is Court TV Live. Let's go back to the courtroom together now.
The court finds that the evidence and the record before the court does not support the conclusion that defendant was experiencing a neuropsychiatric side effect of acne medication, minocycline, resulting in disassociation or confusion at the time these crimes were committed on October 13, 2022. The evidence establishes that for a year prior to October 13, 2022, defendant was prescribed minocycline, an antibiotic commonly used for the treatment of acne. Minocycline has been widely used and prescribed for over 50 years. Dr. Corvin, an expert accepted by the court in the field of forensic psychiatry, noted that an uncommonly observed side effect is an association of minocycline with a range of neuropsychiatric side effects, up to and including confusion and dissociation. He noted that defendant had no other known risk factors for such episodes, nor had he experienced any such symptoms previously. Dr. Corbin speculates that defendant's conduct and writing, coming from an otherwise more or less normal adolescent male, elevates concerns that his conduct may have been influenced by a medication-related side effect, such as dissociative symptoms. But Dr. Corvin then added, unfortunately, given the severely limited data set available for consideration regarding his state of mind on the date of question, he, Dr. Corvin, is unable to offer an opinion with a reasonable degree of medical certainty as to whether or not Mr. Thompson was experiencing dissociative symptoms on the date in question. But these observations are offered for consideration to the trier of fact in the hope that they will be of assistance during the disposition of his charges. Dr. Nuruddin was also accepted by the court as an expert in forensic DNA and serology. He undertook to answer the question of whether defendant's ability to metabolize minocycline could have been altered by his genetic background and consequently increase his risk of experiencing side effects. Dr. Nuruddin explained that minocycline, like most drugs, is metabolized by subunits of the liver cytochrome P450 system. He further explained that specifically subunit CYP3A4 of the P350 cytochrome is involved in the metabolism of minocycline. He hypothesized, therefore, that perhaps defendant had a genetic deficiency in the CYP3A4 subunit that would impair his ability to metabolize minocycline, thereby making him more susceptible to its side effects. His experiment did not prove his hypothesis, but in fact proved the opposite. After extracting defendant's DNA and having it forensically analyzed, Dr. Nuruddin found the defendant had a normal CYP3A4 subunit and hence no scientific evidence of genetic inability to metabolize minocycline. Based upon that, Dr. Nuruddin could only speculate that perhaps further clinical and genomic studies in the future will shed light on whether any other features of defendant's DNA profile might increase his risk of minocycline side effects. The court also finds, based on the testimony of Dr. Corwin and Dr. Nuruddin, that the risk of dissociation side effects from minocycline is infinitesimally rare. In the 55-year history of the widespread usage of the drug, only 2 cases are reported with any details in published studies, and perhaps 40 cases of depersonalization and derealization disorders associated with persons taking minocycline have been tallied without accompanying data on a website maintained by the World Health Organization. Dr. Nordine said that of the very few cases of dissociation reported, it is more prevalent in females and occurs within several days of starting to take minocycline. Moreover, neither expert was aware of any connection between dissociation attributed to minocycline and any violence, homicide, or criminal conduct. Finally, in evaluating expert opinions, the court, as the finder of fact, is not required to accept an expert witness's opinion to the exclusion of facts and circumstances disclosed by other testimony. The court must evaluate the reasons, if any, given for the opinion, whether the testimony is supported by facts that the court finds from the evidence, whether the opinion is reasonable, and whether it is consistent with other believable evidence in the case. Here, the court finds and concludes that the theory that the defendant was overtaken by dissociation on October 13, 2022, at the time he committed the murders, is belied by other facts and circumstances established in this case, including the months of research, planning, and preparation conducted by the defendant, both before and after he was prescribed minocycline, the methodical and deliberate conduct displayed by the defendant before, during, and after the killings, the video footage of the defendants during the course of the rampage, and the written record of defendants' thoughts and actions. The court finds that the theory of minocycline-induced dissociation is not supported by the evidence and is rejected by the court. So, concluding, as I've noted earlier, these findings are not intended to be the final order of the court, nor have I attempted to speak to other mitigating circumstances considered by the court in making its judgment. The final order will contain details on each of these findings, as well as each of the other mitigating circumstances considered and weighed by the court in reaching these conclusions. And having carefully considered all of the evidence presented in this hearing, and carefully considered all of the mitigating circumstances offered by the defendant or otherwise found in the evidence, the court concludes that the answer to the issue before the court at this hearing is yes. Austin Thompson is the rare offender whose crime reflects irreparable corruption. And I shall now enter judgment accordingly. Mr. Thompson, I'll ask that you stand. First of all, let me ask, is there a stipulation that the defendant has a prior record, level 1, based on no prior record?
Yes, Your Honor. If I've been approached, we have it written.
Yes. And let me just verify. I'll get to this. So. All right. Mr. Thompson, this time the court is going to enter judgments in this case. There will be several judgments entered. For the first-degree murder of James Thompson, I'm ordering you incarcerated for a term of life without the possibility of parole in the custody of the Department of Adult Corrections. That's an active sentence. For the murder of Nicole Connors, I'm ordering that you be sentenced to life without the possibility of parole in the custody of the Department of Corrections. That's an active sentence. It's consecutive to the judgment I just imposed. For the first-degree murder of Gabe Torres, I'm ordering you incarcerated in the custody of the Department of Adult Corrections for life without the possibility of parole. That's an active sentence. It's consecutive to the judgment entered immediately prior. For the first-degree murder of Mary Beth Marshall, I'm ordering you to the custody of the Department of Adult Corrections for a sentence of life without the possibility of parole. That judgment is consecutive to the previously entered judgment. And for the murder of Susan Carnatz, I'm ordering you to the custody of the Department of Adult Corrections for a sentence of life without the possibility of parole. It's an active sentence consecutive to the judgment previously entered. For the attempted first-degree murder and assault with a deadly weapon with intent to kill, inflicting serious injury on Lynn Garner, I'm consolidating these offenses into a single judgment. And Mr. Latour, is that a B2 felony, the attempted first-degree murder?
Yes, Your Honor.
Yes. ordering you incarcerated for a term of 157 months minimum, 201 months maximum in the custody of the Department of Adult Corrections. That judgment is consecutive to the judgments previously imposed. And finally, for the attempted first-degree murder, assault with a deadly weapon with intent to kill, inflicting serious injury, and assault on a law enforcement officer with a firearm, and consolidating those offenses into a single judgment. And this is for victim Casey Clark of 157 months minimum, 201 months maximum in the custody of the Department of Adult Corrections. And that judgment is consecutive to the previously entered judgments. And that, sir, is the judgment of the court.
Your Honor, at this time, the defense enters notice of appeal and requests that the appellate defender's office be appointed.
So noted. The appellate defender is appointed to represent the defendant in the joint court.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you, Your Honor. Thank you.
If there's no further business for the court, we are adjourned. We are adjourned. Yes, sir.
All rise. Oh yes, oh yes, oh yes. This Honorable Superior Court for the County of Wake now stands adjourned. Sine die. God save the state and this Honorable Court.
Thanks so much for being with us on this Friday morning. We have to hit a break. We'll see you in just 4 minutes. Good Friday morning to you, and thank you for being with us here on Court TV Live. I'm your host, Julie Grant. Let's get you back into the courtroom right now.
Ladies and gentlemen, here we are, Friday the 13th. Done quite a few trials, and usually they're one day. And the jury gets picked in the morning, and then they hear the evidence in the afternoon, and they deliberate. But you guys have made it through 5 days. Through 5 days, and you paid attention. I've watched, and I thank you for that. So once again, I can't convey that enough, that I thank you that you guys have paid attention. So here we are at the very end, and this is what's called the closing statements, all right? Closing arguments. I'm going to point to the evidence that has come out during the trial. And what I'm going to do is highlight some of the things I want you to remember as you go back there to deliberation to show that the state has met its burden. And that man right there is guilty. Is guilty as charged as first-degree premeditated murder of Demaya Apple. What I'm going to do first is figure out why it's not moving with my screen. Got it, man. Showing what I got. Now we're all right. Back on track. All right. What you'll find by the end of this is that Miss Demaya Apple is a human being. No matter what anyone else says about her, no matter what path she was headed down, and no matter what anybody thought, Demaya Apple was a human being. I'll start the story from the beginning of this little episode. So October 16th of 2022 is most of what you've heard about. But just prior to that, all right, just prior to that was a little incident between two people of the same age, on and off again, of a teenage relationship. Keith Anderson and Demaya Apple. Keith Anderson and Demaya Apple had somewhat of a normal relationship, which dating may last 2 days. Then break up, dating may last 1 week. You know, and that's how it went. Demaya, as you heard Miss Valentine testify to, Amy Valentine, was still sweet on Keith. She still liked Keith. Keith at the time did have another girlfriend, and as you heard, the weekend of 2016, October 16, 2022, Keith Anderson was actually in Lake City with his girlfriend and his girlfriend's mother. He was staying at their house in Lake City. Miss Appling posted something that was inappropriate. A kind of seductive picture. She posted it on social media, and about a 45-year-old man replied to it, talking about how good she looked. Keith Anderson replies back something to the effect, she's a minor. Well, It's not long after that, we begin to get into some text messages. And I'm going to go over these text messages with you. So what I want to set the scene is, you got two young and dumb teenagers. And they have a relationship, then they don't have a relationship, then they have like teenage arguments back